They're loading. You should be ready in the next, I'll say 20 seconds. And we're live.
Excellent. All right. Welcome, everybody. This is Housing Court Answers, our workshop on deregulation risks for rent-stabilized apartments after HSTPA, the 2019 changes in the rent laws. And we have some great presenters here with us today to give us this presentation from Brooklyn Legal Services and Communities Resist. I think our presenters are going to introduce themselves.
Hi, my name is Natalie Gontrov, and I'm a senior paralegal advocate. I work at the Tenant Rights Coalition of Brooklyn Legal Services. Our work primarily focuses on group and affirmative litigation. We focus our work working with community partners such as Flatbush Tenant Coalition, Crown Heights Tenant Union, Hope of UHAB, and other community-based organizations. Yeah, nice to see everyone. Thank you for joining today.
And hi, my name is Parker. My pronouns are he, him, his, and I worked with Natalie in Brooklyn Tenants Rights Coalition. Glad to be here with y'all.
Hi, everybody. My name is Sam Kira. I'm an attorney with Communities Resist. I primarily represent low-income tenants associations and landlord-tenant disputes, helping tenants associations bring lawsuits against their landlords for repairs against harassment and discrimination in North Brooklyn. And I'm very happy to speak to you today about the warehousing component, or rather the Frankensteining component of this presentation.
Hey.
Also, because I forgot to say it, I'm also an attorney. I forgot to mention that.
Small details.
Yeah.
Yeah, so this is here is an overview of the topics that are going to be presented on. We're going to start with an overview of how things changed in 2019. And then there will be different segments on the different loopholes for deregulation. First, substantial rehabilitation, and then demolition plans, and then Frankensteining, co-op and condo conversion, and then J51 and 421A tax abatement programs. And then after, there will be a place for final thoughts and questions. And just as a note, right now we are in March of 2024. There have been changes in the law recently, and even just 2019 was a big change in the law. So everything here is kind of time sensitive. Our presentation is going to live on YouTube, but it's just important to know that the law does change over time, often because people fight to change the law. So, see, I'll turn it over to Natalie.
Thank you. The thing I'm going to talk about now is universal advice when it comes to fighting deregulation. I think the most important advice I could give tenants and tenant groups is to organize and organize some more. And if you're out of ideas, continue to organize. It's probably the greatest strength that tenants have is their organizing power and the power of working in unity. I do legal work, and I have really seen this play out. And one of the greatest lessons of doing legal work and any kind of social justice, to be honest, is that the law is just frankly punitive and abusive, but tenant power is fierce and unstoppable. So ultimately, organizing is how you get the job done. Time and time again, I've seen this come true. And tenants have a right to organize. Tenant associations in New York City, you have a right, you don't have to fight alone, and you can form a tenant association, and the landlord cannot retaliate against you for doing so. I would also recommend to reach out and work with your local tenant rights organizations for assistance. On the presentation here, everybody will be able to download this on YouTube. And when you have access to it, you can click on this link and get a list of community-based organization partners that sort of help assist tenant associations. So there's a lot of them in different neighborhoods. Just reach out, don't fight alone, work with your neighbors and work with community-based orgs. And when it comes to like notices from DHCR or from your landlord, it's really important to like respond, to challenge it, and don't ignore notices. And most importantly, because this is probably the most common thing that tenants in New York City do, and that landlords are well aware that we do this, is don't self-evict. Just because you receive the notice saying you have to leave does not mean you have to leave. Reach out for legal help. If you're not able to get in touch with a community-based organization, call 311 and you could be connected to a legal service provider and get free legal assistance that way. Especially when it comes to DHCR, extensions are really easily granted, and it's far easier to request more time and take the time needed than to reopen a decision that's already been made. And then I have this little image here of a blindfolded referee, because that's kind of how I feel about DHCR when it comes to landlord submissions, which is DHCR will not independently do any fact finding if tenants do not present information to the agency. So as an example, let's say you're being overcharged and it's very clear on paper, just by looking at your rent history, that there is fraud happening. DHCR will just put that paper away. They're not going to look at it until you're like, hello, clear overcharge, please take a look at it. And here's why. So don't just allege things, present facts, and challenge everything you get. So yeah, then that's all.
All right, thank you very much. Okay. And next, I think Parker.
Yeah.
Okay.
So the HSTPA, as Sarah mentioned, back in 2019, there was a big package of legislation, the Housing Stability and Tenant Protection Act of 2019. And this overhauled housing law across New York. Like, there are several trainings that go into the minutia of it. We wouldn't have enough time here to go through everything that changed. It overhauled private housing, public housing, rent stabilized, unregulated, all of it. So for now, just kind of bird's eye view, 20,000 feet, a couple of things to know about how it affected rent stabilized tenancies. First, it changed the rules around preferential rent. Prior to the HSTPA, a landlord could offer you a preferential rent, which was lower than what they were legally allowed to charge. And then after the first year or 2 years of your tenancy, depending on how long it was, they could say, okay, your preference ending, we're going up to that higher rate. And that was a common thing that a lot of New Yorkers experienced. With the HSTPA, they've locked it in. If you start with a preferential rent, that preferential rent stays for you until you leave. Only after you leave can the landlord go up. Relatedly, one of the big changes to how apartments are deregulated was the end of high rent vacancy deregulation. Now, what that means is, prior to the HSTPA, with every tenant that left, the landlords were able to raise the rent, and if it went over a certain threshold, it started out at $2,000 a month and went up to $25,000 and kind of went up over time. If the rent went over that, the apartment automatically became deregulated. That's now ended. So high rent vacancy is no longer a thing post HSTPA. Relatedly, the Major Capital Improvement, or MCI, which I believe there's already an HCA training on that topic post HSTPA that you can find on their website. Major Capital Improvement was a way by which landlords were allowed to invest in a property and then raise the rent based off how much money they put into the individual units or the building-wide facilities. MCI is still allowed. And prior to the HSTPA, it was used to deregulate apartments with that high rent vacancy. Since high rent vacancy is gone, MCI is also no longer allowed to deregulate. So why I'm telling you about these couple of things, these are ways that landlords commonly use to deregulate apartments. that have now been closed. So rent stabilized housing stays rent stabilized housing. Today's presentation thus is going to be on the remaining ways that an owner is able to deregulate rent stabilized units and what can be done to challenge that process. As Sarah mentioned, today's presentation is current to today, March 29th, 2024. But today's presentation includes changes that were effective January 1st of this year. That is to say that amendments and changes are happening every day. So given that this is an evolving area, the further out we are from today, the more likely it is you should check with a community legal service provider to see if the information is still accurate or if something's changed.
Thanks, Parker. So now Natalie is going to get into the fascinating topic of substantial rehabilitation.
Thank you. So substantial rehabilitation. What is it? So basically a landlord can take a building out of rent stabilization status or deregulate a building. If the landlord can prove to DHCR that a building has been substantially rehabilitated. DHCR is a state agency that governs rent stabilized apartments or rent regulated apartments, for those who have not heard. I have in the slide for you, if you take a look at it later, a fact sheet, but you could also Google DHCR fact sheets. They have a lot of really useful information, and they have one that's most relevant on substantial rehabilitation. So now I will talk about what criteria the landlord must meet in order to get substantial rehabilitation. So landlords must prove, there's several steps that the landlord must take. The first one is that the landlord must prove that at least 75% of the building-wide or individual housing accommodation systems were replaced. When I say systems, what I mean is plumbing, like all the electrical in the building, all the ceilings in every apartment, the whole roof on boilers. It can't be partially. What else? There are exceptions. So let's say a landlord applies for substantial rehabilitation. If the landlord can show that a particular system has recently been installed or upgraded, or is structurally sound, and it doesn't require replacing, or is desirable or required by law due to the aesthetic or historical merit, then they can show that they did 75% of the systems minus these particular systems that fall into that category, but they would have to prove it. So that's just one exception to the 75% of systems. So globally, just to reiterate, this first point is probably the most important. You know, if you're someone who's dealing with your landlord attempting sub-rehab, take a look around. Does it look like, you know, the majority of the systems in the building have been replaced? The next point is that the rehab has to take place when the building was substantially or in serious deteriorating condition. So that means that the majority of the building has to be sort of, you know, deteriorating, falling apart. And the next thing is that all systems must comply with the building code's requirements, and the owner must submit copies of certificate of occupancy. So that means, you know, if you're calling 311, you're engaging with the city because there are legitimate violations in your building. This is one way to be able to try to stop this, but we'll talk about that more a little further down. And more recently, literally just a few months ago, there was another rule that was passed that for substantial rehabilitation performed after January 1st of 2024, owners must seek approval from DHCR within 1 year of completion. So in the past few years, we've seen tenants get substantial rehabilitation notices that say your landlord did work 20 years ago, and now they're saying it's going to be substantially rehabilitated. That is no longer going to be allowed. Any work that was performed after January of this year, they have to get the approval within 1 year. They can no longer wait to ask for it 10 years down the line. So those are the criteria. There are some exceptions to the criteria. For instance, if the landlord, although really, really rare, next slide, please. The exceptions are if the landlord was convicted of arson to create the vacancies, right? Because part of the substantial rehabilitation, you have to show that the building is deteriorating, which often means that you have a lot of vacant units. So if they were convicted for the arson to create the tenancies, they cannot get substantial rehabilitation. Or if DHCR or government agency has a finding of harassment. So you've been able to get a declaration of harassment, whether via DHCR or in housing court, they also would not be able to get the building to be substantially rehabilitated and essentially deregulated. Tenants who lived in the units, so occupied apartments during the rehabilitation work, remain rent stabilized. But when they move out, if the building has a substantial rehabilitation order, then the next tenant becomes market rate. They are deregulated after that tenant moves out. So as long as you continue to live there during and after rehabilitation work, you and your family continue to be rent stabilized, but the following tenant, once it's vacated, is no longer rent stabilized. Similarly, apartments that were vacated apartments, so let's say there was a fire or some kind of damage that led for the city to vacate the unit, they remain rent stabilized if the vacated tenant moves back, but not the following. Okay, next steps. And I do see some questions in the chat. After I complete this section, I'll answer them. So just keep putting them in there, please. Okay, so what are the steps? And after explaining the steps, I'm going to talk to you about how to challenge this. But the steps are, first, before the owner even begins to attempt this, the owner can apply for a DHCR advisory if it plans to qualify for rent for sub rehabilitation, meaning that they can get like essentially a type of prior approval. Although it's not an official order, DHCR can issue an advisory. So the first real step that the landlord has to take is they have to file an application by the owner to determine whether a building or apartment is exempt from ETPA or the rent stabilization law. And the form is called RS3. The tenants then receive a notice, which is called the Notice of Commencement of Proceeding for an Order of Exemption for Rent Regulations. Tenants can file a response to this notice within 20 days of the date appearing at the bottom of the notice. Throughout that, after you receive that notice of commencement, tenants or landlords may receive one or several requests for answer, additional information, or evidence. There are various ways that DHCR names these documents, but essentially it's a request for information. An answer is just a request for a response. So those words can be used interchangeably by the agency. The response is usually due within 21 days, but you can request extensions for responses and get more time to meaningfully respond to DHCR. On the next slide, what I did is I redacted a DHCR notice. This is the one that you get when you first find out that your landlord has applied for substantial rehabilitation. And but this is essentially what they all look like, except instead of saying notice of commencement, it might be like a request to answer or respond. And on the top right corner, you see the docket number, which applies to the number of this, the number that represents this case that the landlord filed. So this is essentially what they look like. You see the DHCR logo and name and address at the top. So that's how you know you're receiving it from this regulatory agency. Okay. So the next step is that the tenant receives, like once, you know, so the landlord filed, you got notice that they filed, maybe there has been some requests for answers, requests for information, requests for respond. And then the next step is the tenant or landlord receives what's called an order or determination. And in this order or determination, DHCR can reject the landlord's filing for substantial rehabilitation. The owner can still qualify for individual apartment rent increases or major capital improvement rent increases, also called IAIs or MCIs. Or DHCR could issue an order allowing the substantial rehabilitation. An important note that if this notice, the order and determination, is the first time you're receiving a notice of substantial rehabilitation filed by your landlord, it may be the case that the landlord excluded your unit from the application. It's very important that at the very least you inform DHCR that you lived there throughout the time of the rehabilitation and should have received notice. We absolutely have seen landlords exclude a tenant who was currently living there. And if you look at the documents they submitted, they claimed that this unit was vacant. So therefore, DHCR did not give notice to the tenant of the landlord beginning this application. So once you receive this order, it's not the end of the road. The tenant, once you've received the order, the tenant within 35 days of this order can still file what's called a petition to administrative review. We also call it PAR. At which point, basically, you ask the agency to look at the facts they already have. So you cannot present new information. They will not take new information from you, even if it's very impactful to the agency's decision. They only basically look at the record, but you can uplift certain points you might have made or expand on points you might have made to DHCR throughout trying to challenge the substantial rehabilitation. And finally, although rarely used, step 6, if there was an order for substantial rehabilitation and either the tenants filed a petition to administrative review or they didn't, and ultimately the order went through, if in the future there's a determination that any kind of fraud was involved, tenants can ask DHCR for a redetermination. So it's not necessarily the end of the road, but one last option. So the next section, next slide, please. I'm going to talk about challenging substantial rehabilitation. So the most important thing is respond timely, challenge, and don't ignore the notices. We have seen DHCR and their decisions, even if you give them really important facts and you show proof of some kind of fraud, but because you didn't respond timely, they get to just ignore your facts that you present to them. Going back to the, blindfolded referee, just as an image of how DHCR functions. So some things are important is that you have time. So, and take the time you need and get the time you need. So just because you receive a notice saying you have to reply in 21 days does not mean that you have to request extensions whenever possible. The first notice of the landlord filing this that you receive, you can request up to a 90-day extension in order to get more time to respond meaningfully. You could also, in the second order, like once there's an actual order for substantial rehabilitation, once DHCR has made that final decision, you can make a request for records, which is the Rec 1 form, and ask for a full copy of the case. And once you actually receive that full copy, which sometimes, depending on how voluminous the case records are, DHCR can take a week or two, or sometimes several months, to give you the full copy of all of those records. And only when you receive the full copy does it start the 35-day clock for you to have a deadline to file the petition to administratively review, which is also called a PAR. You can also review if the owner applied for an advisory opinion prior to filing for substantial rehabilitation to see what was the agency's determination and what facts the landlord presented. Throughout the time that you're, at any point or any DHCR cases, there's a link here for a case status search. So you could actually go on the DHCR website and see what phase the application is in. You could see if it's, under review, or there's a final order, or maybe it hasn't even been assigned to a worker yet. Until there's a final order, you can always present more facts to the agency. Even if it's past the deadlines, you can always just continue to do that. And I think the most important thing, which goes back to my initial point of an overview, is just to work with your neighbors. Don't do this alone. And if one doesn't already exist, form a tenant association in your building. Other tenants may be concerned about the substantial rehabilitation paperwork, but unless you guys get together, it's going to be hard for you guys to collectively fight it. Okay, next slide, please. So in the initial response, it's important that you don't need to have all the facts. You can send what you have and reserve the right to supplement filings. And you should absolutely do that, even if you don't think you will, because you never know what a year from now, as this case continues, you might find out, or what you might learn. And you also, I would recommend at the bare minimum, is request DHCR to inspect all the systems that the landlord alleged. So going back to the landlord having to, change 75% of the systems, you can ask the agency to review if that is actually true and do their own independent analysis. It's no guarantee that they will come out and inspect, but it's a good idea that you try it. Although this doesn't change the facts and the law, because the law is unjust and punitive, tenants can write their own stories, their narratives, or I would like to call them gentrification stories of their experiences with the construction or rehabilitation work or lack thereof. Let's say you receive this notice, there's never been construction, and how this has affected your building, your neighbors, your neighborhood, and your community at large. I think it's important to have that narrative in there, or the gentrification story, because at the end of the day, we are human, and the people who are reviewing these records are also human. And it's important for us to get to the nature of what we're really talking about, which is, housing destabilization. And DHCR needs to know how this affects the communities there. It's not just about a substantial rehabilitation. This is a way to deregulate housing, to take away affordable housing and increase gentrification, right? Another thing you could do, if you're not already in housing court, where you could have a defense of harassment, you can file a DHCR harassment claim. So DHCR has a form where you could file that your landlord's been harassing you. And what that would do is start a type of mediation process where it could lead to the landlord having a finding of harassment. And if that happens, the building cannot be substantially rehabilitated. It will be exempt from that. However, what it also essentially does is it puts the application on a pause. DHCR cannot make a decision on a pending substantial rehabilitation application as if there's a pending harassment filing. So that's another tactic to kind of delay and get yourself some more time. And then tenants who've been vacated due to, unsafe conditions like a fire or water damage, or tenants that were temporarily located. Let's say the landlord asks you to remove somewhere while he does this renovation or whatever they call it. You can file a rent reduction order with DHCR. And I highly recommend doing so, preserving your rights to that unit for when you return. Okay, next slide. Gather your evidence. So here are some tips on gathering evidence on how you can challenge the substantial rehabilitation. First, throughout the application, like after the landlord files, when you receive notice, a few months later, wait a few more months, do it again. Just do this throughout, is to request a full case file record. So DHCR, just because your landlord submits things to them doesn't mean that they will show you as a tenant what they've submitted, but you can do a full case record review, and you could ask for that through the Rec 1 form, and you could see everything they've ever submitted, anything you or your neighbors have submitted. This is one way of learning if any of your other neighbors are actually challenging this application. And when you receive those records, look at their spending. Does the money add up to what they're claiming? You'd be surprised how often a landlord claims to have spent a certain dollar amount, but they have no proof of it in the actual application. And like I said, DHCR has their blindfold on. So if you don't point that out, they're not going to affirmatively look at it themselves. Similarly, confirm that the itemized list is available, that there are dates that match the application. In the form that the landlord files, they have to say when the work was done, and if their contractor permits, affidavit from the contractor explaining when they do the work. If the dates don't match what they put in the application, it's really important to point that out to DHCR, because like I said, they don't affirmatively look at any facts unless you point it out. You can also look at the application and permits on the Department of Buildings website. You can look how many units were vacated, if any, during the rehabilitation work, which I'm sorry, I'm not sure why the link's there. That was a mistake. And then I put some helpful links here. The first is where you could see Department of Building violations, and the second is where you could see HPD violations. So let's say one of the systems that the landlord alleges to have fixed is the roof, but tenants continue to suffer from leaks from the roof. It's really important that folks call 311 and place those violations for the roof leak. And then in your challenge, you write like, hey, look at these violations, look at these photos of what we're living with. Similarly with DOB, let's say they replaced the elevator and you're seeing live violations for elevator. That's the kind of information you want to present to DHCR. these are three regulatory agencies, but they do not talk to each other. So just because there's a violation for elevator on DOB does not mean that DHCR will look at that. You have to actually present their website printout to DHCR in order for them to consider that fact in challenging your substantial rehabilitation. And here I have some ways that you can report violations ongoing. I mean, just generally speaking, you always want to preserve information of what you're living with. So call 311 and report any ongoing violations, not just the ones that report are about the sub rehab, but generally. And you could call 311. You could also text. I put in the text number here. And also you can report violations through the 311 website. Okay, so the next section is just the lastly, what else you can do to challenge substantial rehabilitation is to gather evidence. You can, just other ideas for gathering your evidence. You can chart out the systems, like draw out the systems, whatever you need to understand what are the 75% things they did here. Okay. You can also do what's called a FOIL, a Freedom of Information, on the DOB website, where you can put in the job numbers that they claim that they did work for and actually FOIL and get every document they submitted to this agency. And I put in the link there for you. You can also go to DOB, because a lot of DOB website and information that you get from them is just like made for contractor language. It's not really legible to regular humans that don't do construction work. And you could actually ask DOB tenant advocate direct questions. You can do so by calling 311. They will connect you to the DOB tenant advocate, or here I put in their actual email, which is tenantadvocate@buildings.nyc. You could also go to Department of Buildings after hour information sessions. These are made for tenants on the first and third Tuesday of every month. They're from 4 to 7 p.m. in every borough Department of Building office. You could sit there and be like, what is this permit? What company was this? How do we know if they're licensed? These are all the things you could ask them. And I also recommend researching these companies. It's important to point out, even if a contractor is unlicensed, if you say to DHCR in your challenge, like, this company is not licensed, DHCR will not believe you unless you show them some printout that shows this company is not licensed. They will also, despite this information being easily available online, they will not independently look at it without you pointing it out. So you really have to print for them information that these companies don't have licenses or don't have permits, or if their LLC is not registered with New York State. And I put in the links here on how you check corporation status and license status for Department of Buildings. Okay, so that's the end of the sub rehab section. I guess I'll open it up to questions.
Okay, so I gathered some questions that were put in the chat. The first one is, could a building fall apart to qualify for this?
I mean, yes, absolutely they can. And that's, what tenants sometimes have experienced is the landlord allowed the landlord for the building conditions to deteriorate such that it fell into this category. It's really important for policy reasons to point this out if you're gonna challenge your substantial rehabilitation, so that DHCR knows, like, for instance, for 10 years, they did nothing after fires to rehab apartments. They let the building fall apart. They let the roof leaks continue. And that they essentially did things to push for the building being in deteriorating conditions. However, when you're pointing that out, it's really important that you're also proving the landlord's case that the building is deteriorated. Next question.
Okay, and someone also asks, how do you fight wrongful deregulations?
Well, we're going to talk about that. That's a really broad question, but I just spoke about the sub-rehabilitation challenges. So just take a look at the notes after, and if you have questions, you can reach out, and we're going to talk about other ways of fighting it.
Okay, and somebody asks, what does ETPA stand for? And I think Samuel had answered it, so I'll just repeat it for those who are viewing on YouTube. It's the Emergency Tenant Protection Act, and it extended rent stabilization protections to apartments and buildings built and used for residential purposes prior to 1974 with 6 or more apartments. And there was another question. Hold on. Would installing a video doorbell for each apartment, is that considered cosmetic? What about improving or upgrading a building's backyard that tenants do not have access to? Our tenant's landlord claims it's an MCI.
So that's an MCI question. Once again, I'm not going to get too much into the weeds because we're really here to focus on deregulation, not rent increases, allowable rent increases. But I would just say make sure you challenge and get the facts and work with your neighbors on that one. But when I say 75% of systems, I mean the systems that keep the building running, plumbing, electrical, roof. It usually doesn't include things like a buzzer system being improved, although it can, and it's important to point that out. It's really important to point out cosmetic improvements throughout the building in their substantial rehabilitation. If you open it up and you see that the landlord is alleging that them putting in a fancy lighting system is them substantially rehabilitating it, it's really important to point out that these are cosmetic changes. Or if the landlord is claiming that they did the backyard, and it's really important to point out to DHCR, tenants don't have access to this backyard they redid. So those are important things to know. And like I said, DHCR has their blindfold on, so just point it all out to them.
And somebody also asked, how often has this been happening?
Well, we've been seeing it more and more, but it's been going on throughout the years. I don't know that I can speak to how often, but it is definitely something that landlords do. And post HSTPA, as they have lost many ways to deregulate units, this is something landlords are picking up again. Like with substantial rehabilitation, we've seen more buildings where landlords are claiming that they've been substantially rehabilitated decades ago, suddenly post HSTPA. So more and more folks are coming to us with this issue.
Oh, and this person also asked, could warehoused buildings get deregulated this way?
I think maybe if we could keep that question in the warehousing section, I'm not sure.
Okay, yeah.
But probably, yeah. If you I mean, that's essentially what they do. You know, you experience a fire, tenants are vacated, they never let the tenants back in. A decade goes by, and then they start doing construction, and they claim the units were empty when tenants have valid rent reduction for a $1 order to get back in, and they never have been able to.
I actually have a couple questions of my own on this topic. So I know of a sub rehab building where a lawyer, these tenants luckily were able to get a lawyer, and the lawyer was able to find out that the building had received a grant to do renovations on the building. And part of the language of the grant said, you cannot get sub rehab deregulation. It's like one of the components of getting this, but like they got money from the government to make repairs. And then later on, they were trying to deregulate based on that. I don't know how the lawyer figured that out, but is there a way for tenants to look into this kind of stuff to see what funding the landlord had ever gotten? It's tough because sometimes these claims are going back decades, and already this stuff is hard for tenants to navigate themselves.
That's a great question. I think the thing, and maybe the others presenting can add to this answer, but I would always check ACRIS and see, which is like the landlord's financial information, like how much their mortgage was, and if they did any kind of refinancing, and regulatory agreements. These are not just grants, these are often agreements that they have with state agencies that they will like rehabilitate a building for tax breaks. We're going to get into that a little later on, but that is one of the ways that you could figure out if the landlord's received funding or any kind of tax breaks. And yeah, that is double dipping. Really important to point out to DHCR, regardless of whether it's approved or not, just for them to know, because they will not independently look for those records. Yes, DAP portal. Thank you. I also love the DAP portal. I'm going to talk about it a little later on. It's one easy way to see and be connected to every one of these websites, Department of Buildings, HPD, ACRIS, where you see the landlord's finances, and other really important, useful information.
And I had one other thing. their question. At Housing Court Answers, we often see the petitions that start cases against tenants, eviction cases against tenants. And I often notice when in the paragraph where they talk about the regulatory status of an apartment, I just often see where a landlord their lawyers have written, this apartment has been substantially or is deregulated because of substantial rehabilitation. How could a tenant double check that fact?
What I would do is I would go to DHCR and I would do the Rec 1 form. First, I would get your rent history and see if there's any case numbers at the bottom of that rent history. And then I would do the Rec 1 form, the request for records, to look at any of those docket numbers at the bottom of your rent history. And just any records related to any substantial rehabilitation, individual apartment improvements, or major capital improvements in my unit or my building. And then you should be able to open up the can of worms about other documents. If you didn't receive what you requested, write to DHCR again and just continue to request those records until you absolutely can. Should be, if they're claiming that in housing court, you should be able to verify if that's true, if they actually have a substantial rehabilitation order.
Yeah, thank you. So I think we are going to move on to the next segment. This is fascinating stuff. Just a moment. Okay, thanks, Natalie.
All right. And then just one other thing that I want to uplift, Tiara put in, if you have any questions, call the Housing Court Answers hotline at 212-962-4795 for individual questions. Just today we're kind of doing general, and we might not be able to answer about your individual building. So let's talk about demolition. If substantial rehabilitations are a replacement of 75% of the systems, demolitions kind of the replacement of everything. The big brother, if you will. So demolition. Demolition, as it's defined by DHCR, is the removal of the entire building, including the foundation. And the owner saying that they plan to demolish a building is grounds for them to then ask DHCR for permission to stop renewing rent-stabilized leases and for permission to either relocate or just buy out all of the existing stabilized or rent-controlled tenants. I say rent control for a reason. Rent control is a rather rare thing today. I believe there was reporting from the city from earlier this week that had the number of rent control units in New York City at about, I think, 24,000. So it's very rare as compared to the nearly 1 million rent stabilized units. If you happen to be one of those 24,000 in a rent controlled unit, if you get any notice talking about demolition, it's very important that you reach out to a community legal service provider and to read up all the fact sheets because you have additional protections that I'm not going to be talking about today because today's presentation is focused on rent stabilized tenants. Now, for more information on this, I'm including the links here. You'll be able to download the show afterwards. Links to DHCR's fact sheet number 11, which is the kind of short fact sheet about demolition, as well as their operational bulletin 2023-2. That bulletin, which was just released, I believe it was revised in early February. It's kind of the latest on how DHCR understands and approaches demolition applications. And it has excruciating detail for each step of it, as well as how much the different stipends are under it. So next slide, please. Okay, so demolition. In order to demolish a building, generally the owner has to meet two criteria. First, they have to show to DHCR that the plans to demolish the building have already been approved by the Department of Buildings. So before they go to DHCR, they first have to get together their plans, all the contractors, the safety plan, everything, and send it to the Department of Buildings for approval. And that being approved is a prerequisite to going to DHCR to ask to end leases. Secondly, the owner has to prove to DHCR that they have enough money to, quote, complete the undertaking. That's the language DHCR uses, as well as I believe the Rent Stabilization Code. That means here, like they need to show they have enough money to pay for the demolition, as well as to pay for relocating and moving stipends, buyout stipends, everything for the tenants, which is a sizable amount of money. Typically, it's going to be in the at least in the millions that they have to prove that they have ready to go, like in a bank or with a letter of commitment. If they can show DHCR those two things, generally DHCR is going to say, okay, your demolition application can proceed. It's time to have this whole back and forth process, very similar to what we had with subrehab. During their demolition application, the owner has very strict rules about when they're allowed to end leases and how they have to send notices. I'll get to that in a minute, but for now, it's just noting that when leases are coming due, the owner has certain things they have to do timely, or else the whole application can be denied. Lastly, when they're going through with this demolition application, even if it's granted, the owner doesn't simply have the right to evict the tenants. Instead, if DHCR grants the owner's application to demolish the building, the owner gets a choice of one of three options. The first option is to relocate the existing tenants at the owner's expense, so the owner has to pay for the movers, to a cheaper or same cost rent stabilized apartment that is closely proximate. Here, that just means that the owner has to move the existing tenants to a different building at the owner's expense, and the rent at that new building has to be cheaper or the same price as the tenant's current rent. Option two is that the owner can relocate existing tenants at their expense to a more expensive rent stabilized apartment. And they have to do it again. They have to pay for the movers. If they're moving to a more expensive apartment that's nearby, they have to pay the tenants the difference in 6 years worth of rent. So if your current rent stabilized apartment was 1,000, new one's 1,500, the owner has to pay you that $500 difference per month multiplied by 72 months, 6 years. Because that's how DHCR sees this, is if you're losing your rent stabilized apartment, you should be able to afford your new rent for 6 years at minimum. Option three, which in my experience, I've seen a little bit more often. The landlords say the owner will pay the existing tenants a lump sum stipend. So it's essentially a large buyout. And that buyout has to be calculated based on what your current rent is and what the city says the average cost for unregulated housing is. So the difference between that, if you're in a 4-room apartment, I can't do the mental math in my head right now, but it would be like pretty sizable difference between what you're expected to pay for a rent stabilized unit in a 4-room apartment and a unregulated one. That difference is then also multiplied by 72 months for that 6 years number, and the owner has to give the tenants that larger lump sum as well as a moving stipend. That amount is typically, in my experience, going to be somewhere in the 6 figures. Like it's a large sum that the tenants have to be paid, but then the landlord can kind of walk away with it. They don't have to move you to a new unit. Next slide, please. Okay, so first I'm going to go through the landlord's procedure for filing the demolition application, and then I'm going to discuss what the tenants can do to challenge it. Very similar to our sub-rehab. It's like poetry, it rhymes. So first off, the owner has to, as said before, file their demolition plans with the Department of Buildings. They do so with a plan called a PW1, a plan work application. The only reason I'm telling you what that is that application has some very specific sections in it. The last section, I believe it's section 26, down at the bottom, has a bunch of affirmations that the landlord has to say there's this many rent stabilized apartments, this many rent controlled apartments. Here's what's going to happen with them during the application process. And the owner has to swear that all of that is true. So when the owner's filing this application with DOB, what they say there, DHCR is going to hold them to, and as tenants, if you can challenge it, that matters. If the Department of Buildings approves their demolition plan, then the owner can file their application with DHCR asking for permission to stop renewing leases and for certificates of eviction in order to evict any tenants who decide to stay after their leases are up. The application that they file with DHCR is called a Form RA54. Again, the reason I'm telling you that is because it'll be on each of the pages that a tenant gets when DHCR notifies them. So the owner has to include with that Form RA54 all of their approved plans of the Department of Buildings, so it's going to have the construction firms, the contractors, the engineering firms, their safety plan, as well as all their documents proving the money that they have. So it's going to be letters of commitment from the bank, all of that. So it's going to be a sizable packet that the landlord has to send on to DHCR, or the owner has to send on to DHCR. Once DHCR gets that application, that packet, DHCR is the one who turns around and notifies the tenants. And usually that time when the big packet arrives in the mail, that's the first time most tenants learn that the owner plans to demolish the building. Because everything before has been the owner communicating with the city. There needs to have been no conversation between the owner and the tenants. DHCR will send all the tenants this packet, and on top of it will be a notice explaining that the owner has filed to demolish the building, that the tenants have 20 days to respond, and instructions on how to send in this response. The packet has the application's docket number. There's a different docket number for each apartment. It'd be relevant because if you don't include the right docket number, DHCR can sometimes misplace or take a while to figure out which paper goes with which application. So make sure that once you've gotten your docket number, you're saving it. Next slide, please. So once that notice is sent to the tenants, they have 20 days to respond, and they should respond. As Ali said with sub-rehab, if there's no response, the owner can be granted permission to evict the tenants by default, and DHCR is essentially acting as a rubber stamp. They aren't going to investigate any of the claims the landlord makes. If they see those two things, DOB approval and enough money to complete the undertaking, they just automatically approve it. If the tenants do respond, that's when tenants' due process rights are triggered. DHCR will begin seeking information from both sides, asking for information. They'll send letters to the landlord saying you have this many days to respond to our questions, letters to tenants saying the same thing, and DHCR may decide that they want to set a hearing to determine any sort of factual questions, or they may just issue a decision on the responses that are sent back and forth. During the pendency of the application, the owner has to serve termination notices saying to the tenants, not only have I applied for demolition, but now that your lease is coming to its end, I'm terminating your tenancy. Those termination notices need to be sent in a window period. That's a term used by DHCR. That period is not fewer than 90 days, but not more than 150 days before the expiration of their current lease. These termination notices need to be served. It's a very formal process. And they do not terminate your tenancy automatically, but they are a prerequisite that the landlord has to do in order to have their DHCR application to demolish approved. DHCR eventually makes a decision, and if their application to demolish is denied, then they have to issue new leases. They have to continue everyone's rent stabilized tenancies, and the termination notices are of no force and effect. If the owner's application, however, is granted, then DHCR will say when the owner is allowed to start relocating tenants by option 1 and 2, or to pay them those stipends to move out under option 3. The decision of DHCR can be appealed. First, within DHCR, a petition for administrative review, or a PAR, similar exact process to sub-rehab before. And the PAR can be appealed at the court level. Tenants who refuse a final DHCR order can be taken to eviction court. And because one of the options includes that large stipend, they may not receive the full stipend they would be entitled to if they stay past the final date that DHCR said they had to leave by. Next slide. Okay, so now, what can be done to challenge it? First off, this application arrives. It should be read closely. The Department of Building Plans, as mentioned, especially Section 26 down at the bottom, have important sections the owner has sworn are accurate. So any inaccuracies or lies on it can be a basis for DHCR to deny the application. What that looks like is if the landlord claims that there's only 5 rent-stabilized apartments in the building and you know there's actually 20, that should be brought to DHCR's attention immediately, because DHCR may be more willing to grant demolition if they think there's minimal housing being lost as compared to something like the entire building. Also, when you're reading the application, check that it's a complete demolition. As said before, it's the demolition of the entire building, including the foundation. An often used term in this space is now dirt to sky. Like if you're standing where the building was, you should be able to see dirt below you and sky above you. Prior to the HSTPA, partial demolition was a thing. That was the term, where the landlord was able to demolish, or the owner was able to demolish interior aspects of the building, keep the exterior walls up, keep the foundation, and get a demolition application approved by the DHCR. That is no longer a thing. So anyone who's trying to sneak in a partial demolition now, that should be brought to DHCR's attention. Also, investigate the application after you've read it closely. Very similar process, again, to what Natalie so thoroughly described with the Department of Building Now website. Is the application there? Are the engineering and construction firms that signed off on the plans on the up and up? If you can't find information on the DOB website, or if you have questions about it, the Office of the Tenant Advocate is a resource that can be reached out to, and they can tell you things like whether the like what the affirmations within section 26 of the PW1 means, for instance, not to get too granular.
And
yeah, so
just to clarify, so Office of the Tenant Advocate is different from Office of the public advocate for New York City.
Yeah. Sorry,
It's
with the Department of Buildings, Office of the Tenant Advocate. Yeah.
Thank you.
Yeah, good catch. And then, yeah, the previous section has links for corporation searches and how to communicate with DOB. Next slide, please. All right. Now, it's been read, it's been investigated. Now, how do you respond? The first step to challenging the application, some people use the term answering. That's just kind of legalese, I think. In this case, DHCR usually just requests a response from tenants. That response needs to go in. And if 20 days isn't enough, and it probably isn't, because usually the 20 days starts to run from the date on the initial notice, then request more time to respond. DHCR is very lenient about initial requests for more time and understanding about subsequent ones. So in the first response, if you can't get a full thing out there, ask for 90 days to get more time to answer. In that, again, make sure to include the docket number, which you got on the original notice, so that you can, so that DHCR will know where to process that application to. Once finally responding, the tenants in their response should explain essentially why the owner's application should be denied. This can be kind of twofold. It can be problems with the application as well as the broader tenant narrative. So any inconsistencies within the application, any issues with it, any of your investigation that turned up, the plans not being actually approved, or the engineering firms not being properly licensed, or the affirmations not matching with what the landlord or owner is saying, that should be brought up. But also, tenant narrative of their experience with the building is important. Things like harassment or efforts to depopulate the building. And this is key because, as mentioned before, option 3, which landlords like to use, involves owners having to pay out sometimes 6 figures to each tenant who remains. They're very reluctant to do so. So we've seen very aggressive buyout campaigns, harassment campaigns, holdover cases being brought, things like succession being denied, in order to depopulate the building before they file this demolition application, because every tenant removed before the application is potentially hundreds of thousands of dollars that the owner doesn't have to pay. So any sort of repeated buyout offers or uncorrected HPD violations or any sort of harassment that the tenants have experienced, including tenants who vacated, if they can be contacted, if they can give their narrative, and sorry, tenants who've left, like if they can be contacted, if they can give their narrative, it can be helpful here. And as with everything submitted to DHCR, reserving the right to supplement the response with more information. So first sending in the response, then saying, oh, we might want to add to this later. Another thing that tenants can do to challenge it is to reach out to community legal service providers. As said before, there's the list that I think Natalie has linked that you can go through, kind of see who's in your area, who might be able to assist with it. And make sure the tenants association's working together on this. Like if everyone can put in a joint opposition that really details everything the landlord's doing, that's a lot more overwhelming than each individual application being challenged kind of one-on-one, divide and conquer. If there isn't a tenants association, form one. You have the right to. Landlord can't block meetings and can't retaliate against people for forming one under New York law. Next slide, please. Okay, so applications been received, applications been responded to, what now? As said before, DHCR sometimes fails to send tenants everything that's been going on with the case. So once your initial response is in, tenants should be requesting a copy of the entire file with that Rec 1 form. That's a universal form, a records access request for DHCR. Excuse me. And sending that in to request everything that's been filed on this so that you can see if the landlord has, or the owner has sent in something or not to respond. In that Rec 1 form, be sure to include the docket number, and it can take time, but once you get the full packet, you can kind of see where things are. DHCR is going to respond to both the owner and the tenants with these requests for additional information, and they may set the matter down for a hearing. And the hearing would be at their offices or online. Tenants should respond to everything that DHCR sends. Like if you can't respond within the time on the notice, you should request more time, because a third or fourth request for additional information, if it's not responded to, DHCR could say, well, they stopped responding, let's just issue a decision. And as mentioned before, always include language reserving the right to supplement the response with additional information as it comes. Because you never want to tell DHCR this is the last thing we're sending in, because if you do, DHCR will say, okay, we'll make the decision then. During the pendency of DHCR's decision making, as mentioned, the owner may stop renewing leases. They have to comply with those strict timing requirements. Not less than 90 days, not more than 150 days. And here's what's important. Those have to be before the end of your current lease. Now, there's many landlords who don't issue current leases, or they fail to issue timely renewal leases. And there's a lot of people who have been paying rent under an expired lease for a while where the landlord hasn't sent them a new lease. For those people, if you don't have a renewal lease and you don't have a current valid lease, then there can be no window period. That is to say, if your last lease expired and you haven't got a new one, then there is no such thing as less than 90 days or more than 150 days before the expiration of your current lease. That should be brought to DHCR's attention, because if there's no lease to expire, no termination notice window period can begin. DHCR should deny the application on that basis as well. So all that kind of game playing that some owners do about issuing new leases, this is where that should be brought to DHCR's attention, because not only is failure to issue renewal leases a form of harassment, but here it might be able to defeat the entire demolition application. Once it's finished with evaluating, and finished here is kind of a black box. DHCR decides it's ready when it's ready. We haven't had a great track record of predicting exactly when decisions will come. It'll issue the decision, and we can move on to the next slide. Tenants shouldn't be self-evicting before that final decision, because until then, you still have a right to the unit. Even if your lease is expired, even if there's been a termination notice, it's still your unit until DHCR decides otherwise. So that's key. If you self-evict before then, if you decide to vacate, you might lose rights to the unit, and you might lose any right to the relocation stipends or the move-out stipends under the application if you decide to leave without DHCR issuing that decision. The final decision can be appealed, both the petition for administrative review and the courts, but each stage of appeal gets harder. As with sub-rehab at the PAR stage, you can't introduce new evidence. And at the court stage, they tend to look back at did DHCR make its decision in accordance with its kind of proper procedures and stuff? They grant a lot of deference to DHCR, or a fair bit of deference to DHCR. So each appeal becomes more difficult. At the end of the day, no tenant can be evicted unless the owner has taken them to housing court after all of this is done. Like DHCR doesn't have the power to evict tenants, it has the power to grant a certificate of eviction and tell the owner they can stop renewing leases, but no one but a New York City marshal with a warrant from a New York court can actually evict tenants. However, staying past the final DHCR order's move date can reduce the amount of money that the owner would have to pay to tenants under option 3. The way that that works under the operational bulletin, it goes into more detail, but essentially if DHCR says that all tenants must move by, let's say, December 31st, then for each month after that, so for the month of January, the amount of money that the owner has to pay is reduced by 1/6. So for January, it goes down by 1/6, February, it's down by a third, March, it's down by half, and so on until eventually the owner might have to pay nothing to the tenant, which, given that these buyouts can be, again, 6 figures, it's very important to either be appealing this or to make plans to move in accordance with the final decision. Okay, I think that was basically what I had. So, questions about demolition?
I don't see any questions in the chat so far. So
That's encouraging.
Um,
That must mean I did such a good job that no one has any no one has any questions.
I have a question.
Spoke too soon.
Sorry.
Yeah.
So what happens in housing court? Like, let's say the landlord gets what he wants, the demolition plans, etc. The DHCR says, "We believe you. We agree that these demolition plans are legit, and you're allowed to, stop renewing their leases." What happens in housing court if the tenants are in the middle of appealing? Are they able to get their housing court case paused, or what happens?
That's a great question. So first, it's worth noting that, again, I think we cover this everywhere, but just flagging it, New York has the right to counsel, which means if your landlord serves you with a notice saying that they're taking you to eviction court, and then they file a case and you receive it and you have a first court date, you should show up and ask for a lawyer, because a lawyer that you're able to speak with then and there about your individual case is really going to be best equipped to kind of tell you what your options are and whether um, yeah, what the impact of the appeal would have on your case. As far as as far as what would happen in that particular instance, if there's an appeal, like a petition for administrative review pending, it would be my understanding that the courts should generally grant deference to that. The housing courts in New York have jurisdiction over this, but so does DHCR. And given that this is really a DHCR decision process, that then afterwards the housing courts are basically there to kind of like effectuate it and rubber stamp it, but they're not the ones who want to be making the decision. Tenants should be able to move to have their case stayed while the par is pending. That said, the exact basis for that stay and the exact way in which a motion for that stay would go is ultimately going to be, I believe, up to the courts in that instance. So should definitely reach out to a lawyer if you are in that posture of demolition's been approved by DHCR, petition for administrative review is pending, gain papers sending you to eviction court, should definitely reach out to a lawyer. And I'm seeing here, right to counsel's been problematic. Yes, I have heard. For that note, I would add that there are several different community legal service providers that have hotlines. And if you aren't able to secure a lawyer at your court date, you should be calling them. I know Legal Aid has a hotline, Legal Services has a hotline. I think Communities Resist, like most of these community legal service organizations have a hotline that you can call and speak to a lawyer. Housing Court Answers
Yeah.
also has
Housing
a
court
hotline.
answers
Yeah.
at 212-962-4795. You should definitely, if you're just unsure about access to lawyers, what you can or can't do, like legal advice, you can call the Housing Court Answers hotline and we will figure out who you're able to talk to.
And yeah, and now I'm also seeing a question here from Steve Forrest. Parker, sorry I joined late. A couple of questions. Doesn't an eviction leave a bad stain on a credit report? I think that I'm gonna want to kind of kick that or punt that question because it goes a little beyond the scope of the demolition portion of the training I'm currently presenting on. Um, generally, the impact on credit reports versus background checks and the myriad ways in which landlords are kind of trying to evade the different restrictions on like the what was used to be called the tenant blacklist. Like that's its own kind of area. So I'm gonna ask to defer on that one.
Yeah, thanks.
Oh,
So
and
I
then
think, oh,
oh, sorry, there was
yeah,
one more.
Yeah.
Can I take legal action against the landlord because of demolition noise and lack of services such as broken elevators? Um, okay. Like
yeah.
if that's your own landlord, oh, sorry, did you wanna?
Oh no, I was just going to say, so that might be separate. I think that's separate from what we're talking about, deregulation, et cetera. I mean, it would be more, um, HP actions. Um, yeah, because here when we're talking about demolition, we're talking about landlords having demolition plans that they are trying to use to deregulate the building, just to clarify that for everybody. There's what if the building collapsed? Is that under demolition? Oh, oh no, you're muted. Oh, there we go.
Okay, there. Yeah, sorry about that. These headsets. That's a great question. So a building collapse, if it was like a partial collapse or a full collapse, whether it was demolition or not, that's I think in large part the first thing to examine is to go back to the definition of demolition here, which is the removal of the complete building, including the foundation. Like until the landlord's filing with DHCR requesting permission to do that completely and to stop issuing leases for that. Until that happens, and until their plan is to remove the foundation, I believe that would be categorized under a partial demolition. Now, there is a question about what happens to the existing units in that, and I think that's where we kind of uh, dovetail back to what Natalie talked about with putting in rent reduction orders, asking DHCR to reduce rent down to $1 and paying that dollar to try to or to preserve your rights to tenancy of the unit that's now currently in this like damaged and unlivable state, but preserving your rights to return to it once it's been repaired. So if the building collapsed, yeah, if some of the units are collapsed, if you were one of the collapsed units, I think that would be the first step is reaching out to the hotlines, and in the meantime, requesting that your rent be reduced down to $1 so that you can reserve your rights to return to it once it's fixed. Now, if the landlord turns around and decides, well, this partial demolition or this partial collapse was an issue, we now want to get rid of the whole building. Well, at that point, I think you'd be looking at what we've been describing here, this demolition application. And similar to sub rehab, where like you can't be given the right to deregulate if you're the one who burned the building down or if you're the one who was negligent with it. It would really be a question for DHCR to determine like, was this something where the landlord had an active hand in it? And do they have authority to order that when the building is replaced or repaired, that tenants are restored to their units? But that's going to, again, be a very fact specific and very situation specific analysis. So I would really suggest that you reach out to a community legal service provider about that.
Yeah, thank you. So we're now going to move on to our next big section, Frankenstein. Thanks, Parker. Let's see. Dan there, ready?
Hi, everyone. I'm Sam Kira from Communities Resist, and I'll be presenting on Frankensteining today. Okay, so a little bit of background quickly. Like we put the idea for this presentation together before two things happened. One, DHCR reformed their own internal regulations regarding Frankensteining, and two, the state reformed Frankensteining through the Rent Stabilization Code. But what is Frankenstein, right? It used to be, next slide, please. Uh, it used to be the practice of reconfiguring an apartment, changing the layout of the apartment such that landlords could say, okay, this is no longer the apartment it once was. It's no longer the rent stabilized apartment that it was. It's now like basically a new apartment. It still may be subject to rent stabilization, but I'm going to charge a brand new rent on it. And it allowed the landlord to negotiate like a first rent, right? Negotiate, which inevitably was thousands of dollars higher than market rate rent for the apartment, right? Giving the landlord a very cushy buffer between market rate and the legal regulated maximum rent the landlord could charge. This usually happened and happens by getting an apartment next door or above empty, right? And reconfiguring the apartment by either combining the two apartments together altogether or breaking off a piece of the other apartment or sometimes fairly frequently making the apartment a duplex. This usually happens to first floor apartments by opening up the basement, right? If that's happened to you, you should reach out to housing court answers and maybe speak with an attorney because there are other issues outside of Frankensteining, certificate of occupancy issues, etc., that might apply, and you might want to talk to somebody about that. Um, uh, but the purpose is really, to break these apartments either out of stabilization or significantly raise the rent such that it was, it was more than the market would bear, right? Next slide, please. Not anymore, right? They cannot do that anymore. This has changed, right? The state has disincentivized this program in some, or this loophole in some pretty interesting ways, right? So, back to what I was saying at the top of the presentation, this is no longer really a loophole available for landlords to break apartments out of rent stabilization. The legislature got pretty creative about this in ways that we'll discuss. But this no longer this is no longer a huge threat, right? And what was the threat? Well, primarily, in addition to some of the demolition and substantial rehabilitation issues that the other presenters have discussed, this incentivized warehousing, and you can see why, right? Like if you have a rent stabilized tenancy next to a vacant unit, right? Like get that rent stabilized tenancy out of there, and you can reconfigure the unit and reset the rent, right? This has changed. You can no longer do that in ways that we will discuss. Next slide, please. Okay, so what happened, right? So landlords would Frankenstein apartments together and reset the rent stabilized rent at whatever amount they want, right? They would say that there's a negotiated rent, but often those were ghost tenancies, completely fabricated by landlords, and they could raise the rent by thousands of dollars, right? And this created really perverse incentives for landlords to get long-term rent stabilized tenants out of their homes by hook or by crook. Because if the landlord could get the apartment next door empty, you could be in for a world of harassment troubles, right? It could put $1 million target on your back, and that's true for a lot of our clients, right? These buildings, these rent stabilized buildings, are much more attractive to a potential purchaser if you can rid them of the rent stabilized tenancies, meaning deliver them vacant or deliver them without rent regulation restrictions, right? So this was very dangerous, and it was really adding to the problem of warehousing otherwise usable apartments during a very significant housing crisis. Uh, next slide, please. So what changed, right? So since the fall of 2023, the state has disincentivized Frankensteining by setting the max rent limit of Frankenstein apartments. That's not like a max limit for any Frankenstein apartment. It's a max limit using a certain formula. So we're going to get a little mathy here. try to keep the math super simple, in part because I'm not very good at the math. Next slide, please. Let's see if we can do this. All right, so what's the most the landlord can charge for a Frankenstein apartment now? This is, newly Frankenstein apartments. A landlord can only raise the rent by the amount of square footage added to the rent stabilized apartment. And that's a confusing sentence, right? But the idea is that you calculate how much the dollar value of the square footage of the rent stabilized apartment is. And if you add more space to it, then you tack that square footage value onto the new space. So let's go through for instance, right? So for instance, and again, I try to keep this math very basic. If the rent regulated maximum, the legal regulated rent is $1,000 a month for a 500 square foot apartment, that works out to $2 per square foot. So, pretty easy to figure that one out. If the landlord adds 100 square feet to the apartment, say they open up the basement, right? And they make it a duplex. So now you've got 100 extra square feet from the basement. That no longer just allows the landlord to reset the rent at any amount they can get, right? Rather, it allows for that $2 square foot, right, to be applied to that 100 square feet. So you get a $200 increase, right? And you can see why this would disincentivize some of the real bad acting landlords who've been warehousing apartments for the purpose of Frankensteining them, right? Like now you can really, you can add to the rent, right? But you can add to the rent in a way that is reasonable and is actually tacked on to the original rent stabilized legal regulated rent for the apartment, right? Next slide, please. So what if the landlord shrinks the apartment? Same basic principle applies, but in reverse, right? So let's take that same apartment, right? Say the max rent for this 500 square foot apartment is $1,000. The landlord reduces the apartment by 100 square feet. Since the apartment is $2 per square foot, the rent should be reduced by $200, right? And so how do you get the info going forward about how much the rent was before, right? And how large the apartment was, what the configuration size was? Well, now it's the landlord is required to keep that information perpetually, right? So they can't just toss it out, right? They've got to keep the square footage, documentation of the square footage and the legal regulated rent for any apartment they've tinkered with, right? Both the apartment and the apartment next door, right? So that you can review it and say, okay, the landlord played by the rules and calculated the increased rent, or say it's decreased rent, correctly, right? And we know this because we've looked at this information, right? However, if you want to contest it, the landlord is on the hook to provide you, or the state rather, or a judge, with information backing up that they've done this correctly. Next slide, please. Okay, so what if the landlord combines the apartment with a non-stabilized apartment, right? This was a big problem. Obviously, they were, this is a way that they were like shrinking rent stabilized apartments, increasing the size of non-stabilized apartments, et cetera, et cetera. It doesn't apply now, right? So now if the apartment is stabilized, it's stabilized, right? You can't break it out of stabilization this way. And again, you're stuck with that formula, right? Next slide, please. So, what else changed? So now, if you can show that the landlord got the apartment, one of the apartments vacant, the apartment next door, whatever, right? Both apartments vacant through fraud, harassment, or evasion. The landlord cannot raise the rent on the newly Frankenstein apartment. It's stuck at whatever last rent stabilized rent was, right? So we'll discuss a little bit what fraud, harassment, and evasion might mean in this context. Understanding that this is not a presentation on harassment, to the extent that you might contest the legal regulated rent of a reconfigured apartment, a Frankenstein apartment. Let's have a quick discussion on about what harassment might mean. Next slide, please. Okay, so there's a different definition for DHCR, that's the Division of Housing Community Renewal. We discussed it a little bit today. The state agency that enforces rent stabilization law and code. There's a little bit of a difference between their definition of harassment and the city definition of harassment. But not a huge difference. Today we're just going to stick with the city definition because I think it's a little bit easier to understand. It's a little more specific, right? So the city code defines harassment as a course of acts by a landlord or a landlord's failure to act with the intent to cause a tenant to leave or to give up rights that are related to tenancy. And technically, it does not have to be a tenant. It can be a lawful occupant, say, the person bringing this claim is a roommate, as long as they're lawfully entitled to occupy the apartment, right? Their name does not have to be on the lease to bring a claim for harassment, right? But it has to be, done well. These acts or omissions, failures to act, have got to be done with the intent to cause the tenant to leave or to give up a right, right? The landlord might be trying to deprive you of your right to rent stabilization or your right to safe and habitable housing, right? By not acting, by failing to correct conditions in your apartment, right? Let's discuss a little bit. Next slide, please. Yeah. So what is harassment? It's a confusing topic, right? It's a little weird. Because we all feel like we know what harassment is, but you have to be very specific, right? Like here, we're talking specifically about the city code and how that defines harassment. So some of the landlord's acts and failures that are considered harassment, and it's a long list, but some of them, repeatedly failing to fix serious violations in a timely manner, right? So say like HPD has come out and inspected the apartment and found that there are violations that are hazardous or immediately hazardous and, demanded the landlord fix that within a period of time. And the landlord just repeatedly ignores that, right? The court or DHCR should make a determination, right? Or should take make hold a rebuttable presumption, right? That the failure to make these repairs was done with the intent to harass the tenant, right? The owner can come up with a reason why, another reason that's non-harassment related as to why they failed to make these repairs if they like, but they're on the hook for proving that it was not to harass the tenant. It was not to deprive them of rights related to their tenancy. They couldn't do it for whatever reason, right? Locking a tenant out, removing their stuff, using threatening words or behavior if the tenant refuses to leave. Those are very clearly harassment, right? Like you're doing this to cause a tenant to abandon their apartment, their rights to an apartment, right? And that's the heart of harassment, right? Lying about the rent stabilized status of an apartment, right? Like saying like, oh no, this apartment is not stabilized. It's not protected, right? What are you trying to do? You're trying to deprive the tenant of their rights under rent stabilization, right? Their rights to government assistance, right? Through the regulatory scheme. Making buyout offers without giving the tenant notice of their rights, right? There are a number of different disclosures that a landlord has to make when asking a tenant to leave for money, including for rent stabilized tenancies, including saying you have a right to refuse, right? That you have a right to seek an attorney and to ask for help, right? There are just a number of different disclosures. They have to do it in a particular manner, and landlords often ignore this. But if it's something that happens to you, you should document it. You can always report them. Okay. Performing work without receiving necessary permits from the city. This also prompts a rebuttable presumption that the landlord has done, construction work in a haphazard manner, right, with the intent to deprive the tenants of their rights, right? And what would their right be in that case? It would be their right to government oversight, right? If the landlord applies for the permit while the building is occupied, the landlord, will have to also make out what's called a tenant protection plan, right, to show the city that the tenants are protected during this time of construction. But if they don't bother to apply for the permit, well, then they can skip that as well, right? And so what does that do? It deprives the tenant of their right to government oversight in the form of the Department of Buildings checking in on the work, right, to make sure that this is being done in a safe manner. Okay, next, please. How would a landlord remove a tenant by fraud or evasion? So this is interesting because this is new. This also applies to substantial rehab, by the way. This is also new. It used to be that if a landlord could get a building 80% vacant, then there was a presumption, much like the harassment presumption, there's a presumption that that building was in a deteriorated condition and it qualified for substantial rehab. You can see why this is kind of a perverse idea, right? You don't know how the landlord got the building 80% vacant, could have harassed all these tenants out, whatever, right? That presumption has now been removed, right? Now you have to show that the building was actually in a deteriorated state, right? So I mentioned that just because you can see that there are other ways as well, outside of just pure harassment. The landlord might defraud or get a tenant out through evasion, right? We don't know yet exactly what these terms mean because, as I said, they're fairly new. But here's some scenarios that might apply. Failing to restore a tenant to their apartment after a vacate order is issued and instead renting it to someone else, right? You can see how that might be fraud or evasion at the very least, right? May deprive the landlord of the right to get more money for these apartments through Frankensteining. Convincing a tenant to move out temporarily to perform work. We see this for, every once in a while. And then refusing to put the tenant back in after completing the work. Again, renting it out to someone else, right? That would be evasion, right? Or fraud, either way, right? Yeah. Next slide, please. So why is it important? Why is this important information to have, right? So as I said, earlier, like this was a loophole for deregulation post HTPA that was closed while we were preparing this this presentation, right? In some ways, but it's still important information for everyone to have to know their rights from here on out, right? Frankensteining apartment to increase rents stops now. If you move into an apartment that has been Frankensteined after 2024, right, late fall 2023 or 2024, get your rent registration history from DHCR to see if the landlord has applied the correct amount to the rent. Next slide, please. And right, what if I think the landlord has increased the rent improperly after Frankensteining an apartment? Reach out for advice. I feel like all the presenters have said this, but there are a lot of places that you can go to ask for assistance. You can go to Housing Court Answers. You can ask your city council member, your assembly member, or state senator for help. They might be able to answer your questions themselves, or they might be able to refer you to a legal services provider, or call 311 to ask for free advice from a legal services organization, or call Met Council, excellent resource, and ask about legal services and community-based tenant advocate organizations in your neighborhood, often called CBOs, community-based organizations. They can be an excellent resource, especially if you're seeking to organize a tenants association. I recommend you do if you can, especially if you have, not such a nice landlord. So, all right, questions about the practice of Frankensteining. Anybody got questions for me?
Okay, so I see some questions in the chat. What if the landlord changed the internal configuration of the unit? For example, 3 bedroom to a 2 bedroom during demolition.
So, So that would never, if, or that would not, that wouldn't, the landlord cannot now deregulate the apartment through reconfiguring the apartment, even if it's, it shouldn't have ever been able to do it just by reconfiguring internally, right? Without providing any new space. Um, but yeah, that would not, you would not be able to raise the rent under the new Frankensteining terms, definitely by removing a bedroom. So certainly the last registered rent, legal regulated rent max would apply.
Okay. So the next question is, I think many apartments in my building were renovated without getting a permit,
Mhm.
gutting and rebuilding an apartment in a landmark building, causing significantly diminished sound insulation and
Mhm.
thus affecting quality of life of unrehabbed tenants. Is
Sure.
there any legal recourse at this point?
Well, so as I said, if this was done prior to late 2023, there may not be. If they have, I mean, it sort of depends on what their the basis for resetting the rent here is, right? Like they would have to claim a substantial rehab for the entire building, with the exception of those tenancies that remain rent stabilized because they were in occupancy throughout. But it's very hard to substantially rehab a building, meaning replace 70% of the building systems if they're still, fairly a decent size of rent stabilized tenants still in occupancy. If what they're doing is they're hoping, if they can't really get them out by through Frankensteining and post late 2023, 2024, right? If they combine the apartments before that, then yeah, they can reset the rent. Um, you might have a claim for harassment, especially if they have done work without a permit. As I said earlier, there's a rebuttable presumption that if the landlord has, repeatedly performed work without a permit in a building, again at the tenant's expense, you can show that some of your rights related to your tenancy have been infringed on by this illegal work. You may have a good claim for harassment. You might want to bring that with DHCR, or you might want to bring that in housing court. Speak to an attorney.
So I'm just gonna jump in here because I apologize for not surveying the time super properly. We've only got 15 minutes left in the presentation and two more topics, so I think we'll move on to the next segments of the presentation.
That makes
And
sense.
if there's, yeah, and
Questions
if we have time
ahead
left
to that.
over, we'll keep more Q&A.
Sure.
Yeah,
Okay, well, thank you all.
thank you.
So I'm gonna now talk about J51 and 421A, what these are. There's a lot of words in my presentation. So my intention is to sort of explain it in very broadly for those who may be relevant to. But once you figure out that you're like in a tenant association or advocating with tenants whose building may be in one of these statuses, then I would look closer into like some of the information presented here, but just gonna talk broad strokes, also in the interest of time. So they're both essentially tax credit programs that incentivize landlords to maintain like affordable buildings, which usually means rent stabilized. 421A specifically is a property tax exemption if value of the property changed because of the construction. And J51 is a property tax exemption and abatement for renovating a building that has already been built. And then once the landlord receives the J51 or 421A break, tenants become rent stabilized for at least the time period of the tax break, if not longer. Co-ops and condos are exempt from this rent stabilization status unless it's a mixed use building, meaning that it had both co-op and rent stabilized tenants in one building, or condo. And when it comes to major capital improvement, if a landlord receives a major capital improvement while being in this tax exempt status, the rent can be temporarily reduced in the MCI case or later date with the tax abatement modification case. So you actually have to file something affirmatively with DHCR. And then after the tax abatement ends, the rent is restored pursuant to a DHCR rent restoration order that the landlord also has to affirmatively file. So the next link is the next slide is just important links. So the first one is how to see if your building currently has a 421A exemption. I'm so sorry. This is titled wrong, but it's supposed to say J51. Sorry about that. I'll just fix it now to make it clear. And then the next link we already talked about earlier, but here's the actual link to the DAP portal. You can also Google DAP portal displacement project, and you get this fairly quickly with Google. It's basically like one way where you could see a lot of really helpful links to your landlord, including, their finances, HPD, the Department of Buildings. And at the left portion, it will show if there's any regulatory statuses in your building. And oftentimes, if your building is currently in J51 or 421A, it will show it in there. So just one way of looking that out. But you should still check the websites on that NewYorkCity.gov has in order to verify that info. HPD also has a fact sheet on 421A programs that I linked here, and DHCR has a fact sheet on both 421A and J51. So those are just for your review. Here, the next slide, just how does 421A work? Basically, the tenants may have a right to remain rent stabilized depending on when the construction work took place and if the notices requirements were followed. That is broad strokes the answer. But here I created like a little chart. So let's say a 421A was built, was after 1984, which they all were. The landlord is required to provide notice of the approximate date on every lease and renewal that you receive. If the construction began before June of 2008, notice at every lease renewal and at the initial lease was provided. The unit can be deregulated at the last lease entered into during the 421 tax break. However, let's say the landlord construction is after June of 2008 and the units usually remain rent stabilized for 35 years. After the 35 years, if there was no renewal, often they've gotten a second one right after. And there's a vacancy, meaning the tenants have moved out, then the unit can be deregulated. And another option is if the unit had like high vacancy rent decontrol during the time of the tax break, if the rent went up above the thresholds in the year that were appropriate, and this is before HSTPA, before this was allowed on June 14, 2019, and the 421A expires, the rent is really high, the tenant moves out, then the next tenant that moves in, the apartment is deregulated unless you can challenge the high rent. So maybe they did improper individual apartment improvements, or maybe, there wasn't a higher rent being paid, things like of that nature. Next slide, please. So, and then I'm gonna just quickly explain J51, and then this is really more detail for you, just like a 421A, if you actually need to review how this works. And the fact sheets are confusing, a little chart to kind of summarize how this works. But basically, after J51 expires, the tenant receives appropriate notices, every lease and every renewal, the apartment comes out of rent stabilization status. If not, the tenant may be able to challenge it. And here, similarly, confusingly different, J51 expires if the building was built before 1974 plus 6 and it has more than 6 units. That means that it's inherently rent stabilized. And it wasn't just the J51 that made it rent stabilized, but it's rent stabilized. And if the rent did not go above the high rent threshold during that time period, then the building continues to be rent stabilized. But if the rent did go above the high vacancy threshold, and that happened prior to June 14, 2019, the apartment may be deregulated at the expiration of the J51, unless you can challenge the high rent vacancy. Similarly, if you have a J51 in a building that is not like inherently rent stabilized, so it wasn't built after 1974, or doesn't have more than 6 units. And let's say the tenant receives notices every lease and every renewal of the approximate J51 expiration. Then at the end of that J51 tax break, at the following lease, your apartment is deregulated. However, if you did not receive those notices during that time period of the tax 51 expiration date, then you can remain rent stabilized until the following vacancy. So even if there was no notice, the next tenant that moves in would be destabilized. I might have went into too many details, but the most important thing on the next slide is how to challenge all of this. Most importantly, when it comes to these tax breaks, don't self-evict. Don't organize your neighbors. Don't just leave because your landlord says, you know, your rent's going up, you're now market rate. Look at everything they tell you. You know, share information you learned about the tax break with your neighbors. Make sure you're not alone. Sometimes your neighbor have information that you may not have, may have been there at times where you weren't. Keep records of any notices. I currently live in a 421A building. Every lease I'm saving in a file. If I'm there 20 years from now, I'm gonna have 20 years of leases saved, because I want to show that, you know, I did or did not get the right. Because the way that you can fight that deregulation is if you show that you didn't receive the notices. But how do you prove something you don't know, right? So you really have to have really good record keeping. And the dates of those notices is also really important. Verify any information. You get notices from your landlord or their attorneys. Doesn't mean it's true. A lot of times we've seen landlord attorneys gaslight our clients in writing. Okay, so just make sure you verify everything. Call 311 or housing court answers if you have any further questions. And inform any family members living about their rights to succession. So if you were able to keep that apartment rent stabilized after the expiration of the tax break and you have family living with you, make sure they know they have a right to succeed to that unit. They're not a new tenant. Their vacancy is continued. Their tenancy is continued. So that's the end of my portion. I'm not going to be taking questions until the end, just in the interest of time.
Thanks, Natalie. All right, next section.
All right, so let's talk about co-ops and condos. Now, one thing I just want to flag here at the start before we really go through it is one of the questions that y'all should be considering when thinking about co-op and condo conversion is whether this is something that you want to challenge or if this is something that you want to negotiate your way through. Because for a lot of people in New York City, co-ops are a path to owning your own place. Like they're a way to securing your own apartment in the future. Same with condos. So we're going to go through kind of the basics and how it's challenged and all of that. But one thing is just considering, like, is there a way we as tenants collectively want to go through with this plan, want to turn our building into a co-op and live together without having a landlord anymore? So the basics, though. So just so we're on the same term, a couple of quick definitions. Cooperatives or co-ops, they're a type of hybrid ownership. Essentially what this means is that all of the owners of a co-op collectively own a corporation. They own shares in a corporation, and that corporation is what owns the building. And their shares entitle them to a specific lease for their specific unit. So that type of a lease is called a proprietary lease. And the way that this looks is that for an average co-op owner, they have their share certificates. I might be like, I don't know, 150 shares of their particular co-op LLC or their particular co-op. And their shares entitle them to have this lease that they get. They get to renew their lease. It's not like the co-op's going to take them away, absent like specific situations with the board. But that goes a bit beyond the scope of this. Condominiums are somewhat similar. Condos are where owners own their own individual apartments. Like it's sometimes said that condo owners, they own their four walls, and then collectively they own the common parts of the building, and they share the common costs, but there's no corporate ownership in a condo setup. In a condo setup, just everyone collectively is co-owners. Both of them can still have different boards or different governing structures, but co-ops have hybrid ownership, and condos, you own your four walls. The reason that we tend to lump these together is that the conversion process for co-ops and condos are similar, as is the rights for tenants who are in a building as it's going through the conversion process. And those tenants who decide not to become owners also have similar rights. Today's training and presentation is only going to be, today's presentation is just going to be on the deregulation process. I'm not going to go into like what happens way down the line for people who move into a building that's already condos and co-ops, because that goes a bit beyond the scope of this. The thing to note about this for rent stabilized tenants, conversion of a building from private ownership to co-op or condo, that starts the deregulation process for a rent stabilized unit, but that doesn't necessarily mean it'll be deregulated during your tenancy. Oftentimes, a building that goes to co-ops, all the existing tenants stay rent stabilized if they decide not to purchase, but then future people who come in to rent are now renting a building that's been unregulated. Next slide, please. All right. So criteria, like how the person does this. Well, in these processes, like using all the different language for each different thing, the person who's trying to start the conversion is called a sponsor. And in most cases, it's going to be the owner of the building. The sponsor is going to say, okay, we want to convert to condos or co-op. Well, the sponsor can do so generally if 51% of the existing tenants in occupancy for 51% of the units in the building agree that they want to buy their apartments. The HSTPA of 2019, as we mentioned before, it made a lot of changes. One of the big changes is they did away with something called eviction plans. Prior to the HSTPA, when you were converting to condos or co-ops, a sponsor could do so with an eviction plan where people who weren't purchasing were going to be subject to eviction. That is gone. No more eviction plans. All conversion plans are non-eviction. So anything that says eviction plan when you're looking up resources, that's out of date. Also, prior to the HSTPA, only 15% of the units, tenants, and occupancy had to agree to the plan. Now it's up to 51%. That is a massive change. So now most of the people in the building and most of the units in the building have to be occupied for it to be converted. Other thing to note, the New York Attorney General, the AG, has the power to investigate the conversion and enforce New York's broad anti-fraud laws against the sponsor. This isn't a process that involves DHCR. This is the sponsor writing to the AG investigating and deciding whether to allow the conversion or not. The conversion is not effective until the AG's office has issued a letter saying that they aren't going to prosecute or that they've looked into it and they're allowing it, or that they sometimes they don't phrase as they're allowing it. They say, we're not going to stop you. And until the purchase agreements have been signed and delivered on 51% of the units. Next slide, please. Okay, so the procedure, what's this look like? For the tenants in possession, what'll happen is the sponsor begins by submitting their offering plan, which is a big packet. It's their proposal and plan on how they expect to convert the buildings into co-ops and condos. And it has to be treated almost like an investment prospectus. It has to have a breakdown of what the finances of the building are, what the expected like sale prices is, how much everything costs to run the building, how much the apartments are worth, that sort of thing. That copy of the offering plan needs to be sent to the AG's office. The sponsor also has to send copies of that plan to all current tenants. And they have to do so with a cover page that has bright red lettering on it, and which is given it the name of a red herring packet, which kind of shows a lot about the legal profession. That's what passes for a joke in our circles. So that red herring packet that arrives at each tenant's door has to spell out the same information that the sponsor is sent to the AG's office. Now, the governing body of regulation is predominantly the Martin Act, which is that broad anti-fraud statute. And the Martin Act requires a full disclosure of investments to prospective purchasers, which means this packet has to be a full disclosure of what's the building cost, what's it worth, what's your apartment worth, do you want to invest and buy into it? Now, the current tenants generally have the right of first refusal to purchase the units they're renting before the sponsor is allowed to turn around and sell them on the open market. And again, 51% of the tenants have to agree for the plan to be effective. The AG's office ultimately decides whether the plan is accepted and has to do so before any shares may be sold. Current tenants can send comments to the AG's office asking them to investigate, and that's going to be one of the main ways to challenge it, if challenging it is what you want. And again, conversion is effective once more than half the tenants purchase and the AG's office is signed off. Next slide, please. I realize we've hit 5, so I'll try and expedite it. Consequences. Okay, here's where rubber meets the road. If you decide not to purchase a unit, then rent stabilized units retain their rent stabilized rights for the duration of their tenancies. That includes renewals. If you're a rent stabilized tenant, you decide not to purchase, you're still a rent stabilized tenant even after the building has become condos or co-ops. That includes succession rights. Your family has succession rights to the unit. So if you either pass or move out, as long as the other cohabitation requirements and family requirements have been met, you can succeed to a rent stabilized unit within a co-op or condo conversion. And as long as you're succeeding lawfully, then you then inherit the tenancy and it continues to be rent stabilized. Otherwise, once the current rent stabilized tenants move out, and the buildings become condos or co-ops, the apartments become market rate. Next slide, please. Okay, challenging it. The AG's office can deny the plan, but they're often going to need help from the tenants to know where to look. The other thing to note is that conversion does require more than half of the existing tenants in occupancy to buy. So if everyone together has formed a TA and decides that they want certain concessions for the conversion to go through, that can be enforceable. So once again, we can return to the big theme of the day, organizing being key. A collective group or collective agreement between the tenants, something called a communal no-buy pledge, for instance, has been seen to be enforceable in some instances. And the tenants can collectively negotiate for better terms, such as more control over the bylaws or condo board or better terms for the non-purchasing tenants. So if you and your neighbors get together and agree, okay, 51% of us are going to sign on to a no-buy pledge that we won't buy until and unless the landlord agrees that this is what protections the rent stabilized tenants will have after it becomes condos, that can be a way to get major concessions, especially if converting to a co-op or condo is in most of y'all's best interests. This can be a way to protect the people who aren't purchasing. For specific questions, reach out to community legal service providers to get advice about what more can be done, because this gets into a really technical area of like the Attorney General enforcing anti-fraud laws, not the typical DHCR proceedings that are often seen in cases like this. All right, I think next slide. So yeah, wrapping up, DHCR is not party of this. I think I've said that a couple times. Even if the plan's approved, non-purchasing tenants remain rent stabilized. Even if it's condo, it's rent stabilized, including right to renewal lease until that person vacates. As long as the tenants are rent stabilized, even after conversion, DHCR does still have authority. That's one thing I forgot to mention, glad I'm flagging it now. DHCR is not part of the conversion process, but DHCR can still issue orders for overcharge, harassment, rent reduction orders, and investigate for the existing rent stabilized units even after the building's been converted. So DHCR still has the power to protect tenants. They just don't have the ultimate say as to whether a co-op conversion or condo conversion will be effective. All right, questions?
So we ran over time, and so unfortunately we aren't going to have time to get to the questions that people had about these extra topics. But I just wanted to thank our 3 amazing presenters for sharing this valuable information about deregulation risks. I hope we're able to all retain the message of organize, 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 don't ignore notices, and get help and help is available. Yeah, I guess if people have future questions about these topics, I wonder if our presenters might be able to share, are there ways for people to ask follow-up questions?
I mean, my contact can be shared if people have questions about what I presented on.
Yeah, so maybe an easy way to do this would be to say, if anybody here in this presentation wants anybody attending wants to ask follow-up questions, you can reach out to Housing Court Answers 212-962-4795, and we can try to get your questions to the right people to be able to answer them. And yeah, it looks like people are putting some emails into the chat. Yeah, and again, these laws are constantly evolving. Laws can become more favorable to tenants. We just have to be all looking at them closely and pushing also our elected officials to make the laws more favorable to us. So thank you, everybody. And hope to see you at the next Housing Court Answers presentation.
Thank you, everybody, for participating. And thank you to the presenters. This is a great presentation. Have a great evening.